if it's unlawful for the defendant to do that, correct?
Yes, we do.
So why, if your Article 3 principle is correct?
Because, again, the Article 3 principle is remedying the injury to the plaintiff, or set of plaintiffs, could be many, who are before the court.
Right.
That has collateral consequences.
Counsel,
that could help.
let me ask you on that point, would one distinction be who's bound by the judgment? Like, I'm wondering whether if the plaintiff needs, you can only...
Here's where I think that, at least from my side, it kind of looked like more like Amy Coney Barrett was on the side of the people who aren't shitting all over the Constitution and wiping their ass with it after they're done with like little pieces of it. She seems like one who is not at least fully completely gone. So let's see what she has here.
Only, I think Judge Strauss said in the Eighth Circuit when addressing this issue, you can't peel off part of a nuisance, so the whole thing has to be shut down. Could a neighbor sue affirmatively to hold the nuisance maker in contempt if he started to begin again the nuisance?
That's a great point. It would not be bounding on those collaterally benefited parties, so to speak. I don't want to call them parties because they're not parties before the court. And that, of course, highlights one of the deep problems with the
No, but why
could you
that
do
the
that?
Answer, though?
Could you do that now for the universal injunction? Could a plaintiff, for example, who has the protection of the universal injunction but was not named in the suit, bring a contempt action of the sort I just described?
They could not do that, but what they could do is run to any of 93 other judicial districts and bring their own lawsuit if that.
No. Under the injunction as it stands, under the injunctions as they stand, could a non-named plaintiff who has the benefit...
So getting into the specifics of it and how his part just doesn't make sense. So here we have Marge Simpson, or the other guy, Marge Simpson, and then Justice Amy Coney Barrett here. Coney Barrett? Nice. Absolutely burying her opponent here. Not opponent, I shouldn't say that. The Inspector General before the court.
Benefit of the universal injunction that's currently in place, could that plaintiff bring a contempt proceeding?
We would...
Or I guess I shouldn't call them a plaintiff. Could that non-party?
We would dispute that they would have the standing to do that because it goes to the heart of...
Well, no. Let's see. Maybe I'm not being clear. Assume the universal injunction is good. Like, drop your argument right now.
Oh, I see. Yeah.
As they currently stand, could someone who is not named in the suit but a beneficiary bring a contempt proceeding?
I think that is what the respondents would certainly contend.
Do you concede that the plaintiffs could bring a Rule 23, like the individual plaintiffs?
We would dispute. I mean, we'd have to address the Rule 23 issues, kind of all the criteria as they came up.
But they could seek it. Okay, and then last question.
And they have done that in Western District of Washington. It's just never been briefed because they
Okay, just last question on this point. The states have a different kind of claim for financial harm, and they've pointed out that it would be very difficult to remedy that without some sort of broader relief. I know you contest their standing. I want you to assume that I think they have standing. Why wouldn't they be entitled to an injunction of the scope of the one that has currently been entered?
I would say two reasons. First of all, it's not necessary to provide complete relief to the plaintiffs. What we offered, for example, in the District of Massachusetts in the First Circuit was an injunction that would enjoin the federal officials and order them to treat the people who would otherwise be covered by the executive order as eligible for the services that result in the pocketbook injuries to the states. And there's really no response to that. That is obviously would fully remediate their injuries and does not require the injunction to be applied in all other 50 states. One state comes in and says, well, people are going to move across state lines. Therefore, we've got 21 states in this case who don't want this relief. Sorry, you got to impose it on everybody because it has to be offered to this one particular state. So that's one response. The other response is this notion that the states have to be provided a complete relief because of interstate travel and patchwork. I think that's very effectively responded to by Chief Judge Sutton's opinion in the Second Circuit, where he says this is a problem. If we adopt this logic, it justifies a universal injunction in every single case, and that can't be the case. The Fifth Circuit's recent DACA decision comes to the same conclusion.
What do you say, though, to the suggestion, General, that in this particular case, those patchwork problems for, frankly, the government, as well as for plaintiffs, justify broader relief?
As to the government, again, Chief Judge Sutton addressed that directly as well when he said that's the federal government's problem. In other words, the federal government, for example, in the First Circuit, we offered that as a narrower scope of injunction, and the decision was, well, that would cause you too many administrative problems. And I think Chief Judge Sutton directly addresses that when he says that's a problem for the executive branch.
That's your problem. All right. Yeah. And then with respect to class certification, your friends on the other side point out that takes time, and there are, as you've emphasized, hurdles that have to be met to achieve class certification. And the argument, of course, is that the injury is immediate and ongoing, and as Justice Sotomayor suggested, might be seriously questioned as to its compliance with this court's precedents. Your thoughts?
I would offer a couple of things in response to that. First of all, there are tools for the courts have tools to achieve sort of class-wide universal relief. I referred earlier that we found 4 recent district court decisions where class-wide relief was given a kind of an emergency basis.
And then this is a new stream because I had to shut down stream and then start again, bunch of bullshit. So sorry about that. But I think it's important to remember on this stream, this not gentleman, I shouldn't say that. This piece of human shit will argue one thing and then the next thing in the next court. He has no consistency between the such. If he argues, oh, well, the court will have this relief or have this thing, in the next breath, his plan might be to argue against that next. So he is setting you up for something. If you hear him talking about relief and you say, oh, well, this sounds decent, it's not. It's most likely something that he is already, he would only concede a point if he was already going to fight it on down the way. Or at least that's what we saw in Trump United States. It was very clear that he was willing to argue one thing, but then when it came to time for the very thing that he said might be the relief for people to come up, he argued against that as well. So the very things that he gives you as your remedies for, hey, this is why you should let me do, this is why you should let the executive do what we want, because you have this relief or you have this ability to stop it afterwards. He is also fighting against that stopping, fighting against that relief.
However, more fundamentally than
And you
that,
agree that that's appropriate in certain cases?
it may be appropriate. We do not concede that it's appropriate in this case, but it may be appropriate in other cases. Certainly, it's an equitable tool that is consistent with, for example, the grant of equitable authority in the 1789 Judiciary Act, as this court interpreted in the Grupo Mexicano decision, and honestly, a line of decisions going all the way back to the early 19th century. So there are tools to address emergency situations, but more fundamentally than that, it is a feature, not a bug, of Article 3 that courts grant relief to the people who sue in front of them. So the notion that relief has to be given to the whole world because others who have not taken the time to sue or not before the courts is something that results in all these problems.
Last question. Do we need to reach the Article 3 question? Wouldn't it be wise, even if you were to prevail, for the court to reserve that question rather than decide that Congress, for example, could never endow this court with that authority?
That's exactly correct. The court does not have to rest on Article 3 because the court could say, and as we've argued, and as Justice Thomas' separate opinion in Trump against Hawaii says,
Gorsuch is one of those people that writes decently but is a fucking idiot.
the 1789 Judiciary Act,
At least in my
suits in
opinion,
equity or what the federal courts can
A lot of them, some of them don't even write well, but writes decently, fucking moron.
do. We had nothing like this in mind. And then I point to the language in Grupo Mexicano where the court said there what was an issue was
By the way, don't think that you could take like these justices are like, oh, well, they know more about the law than you. Okay, cool. What did I say? Did I say they were stupid? Did I say they were dumb? Or did I say that they were able to fake a job really, really well for a long time? Yeah. One of the things about this work is you have to be a decent fucking person to do it right. They are not. They're fucking up. Just so you know. That's how I feel about it. That's the real thing. I'm going to play this for a little bit. I got to go grab a water and close the door, but I will be right back. I'm just going to play it. I'm going to back it up here in just a second. We're at 59:35. I'll probably back it
preliminary
up to an
injunction
hour.
that froze and likely insolvent debtor's assets so that the plaintiff could collect at the end of the case. And the court said that's a nuclear weapon in the law, and we're not that had no analog in 1789 in the practices of the Court of Chancery. And if that's a nuclear weapon, I don't know what this is, where repeatedly, 40 times in this administration, we're being enjoined against the entire world.
I'm just going to ask you to put yourself in a different frame of mind. Hard to do. Assume something you won't want to assume. But the assumption that I want you to make is that on the merits, which of course you did not take to this court, on the merits, you are wrong, that the EO is unlawful. And I want to ask you, if we assume that, how do we get to that result on your view of the rules?
It is very difficult for me to adapt the hypothetical, but I will.
I think that that's the important question in this case. Let's just assume you're dead wrong. How do we get to that result? Does every single person that is affected by this EO have to bring their own suit? Are there alternatives? How long does it take? How do we get to the result that there is a single rule of citizenship that is the rule that we've historically applied rather than the rule that the EO would have us do?
Rule 23 would be one natural path, assuming that a class could be certified, which we might dispute in this particular case.
Well, you might dispute it, and I think the question is there a class that's just all children of people who have entered illegally? Is that an appropriate class? Can the same thing be done under Rule 23? Or are you going to tell me that, no, Rule 23 has lots of requirements, and you'll never be able to certify a class like that?
Rule 23 provides the equitable tools subject to rigorous criteria, appropriately rigorous criteria, to obtain that kind of class-wide.
That suggests to me you're going to be standing up here in the next case saying that Rule 23 is inapt for this circumstance with this number of people.
Left at the end of the case. And the court said that's a nuclear
We're just
going
to listen to that part again because it was very important.
That had no analog in 1789 in the practices of the Court of Chancery. And if that's a nuclear weapon, I don't know what this is, where repeatedly, 40 times in this administration, we're being enjoined against the entire world.
I'm just going to ask you to put yourself in a different frame of mind.
This is a really good question. I think it's important for people to do this. The way I've been doing is like line questions, but asking very direct questions to people. If they're saying, oh, well, this won't work, that won't work, this could never happen, that could never, like, or we're not there yet, whatever it is, ask them what their line is. So for him, in this one, it's okay, you're saying that it should be interpreted this way, we should see this stuff, but the important thing is, what if you're wrong? What if you're wrong? What is the actual relief here if you are wrong? See it from our side for a second. If it is found to be unconstitutional, we don't agree with this, if the merits of it are wrong, what then? What is the solution? And it's just the offerings he give are nonsensical. The
Hard to
answers he
do,
gives.
assume something you won't want to assume. But the assumption that I want you to make is that on the merits, which of course you did not take to this court, on the merits, you are wrong, that the EO is unlawful. And I want to ask you, if we assume that, how do we get to that result on your view of the rules?
It is very difficult for me to attempt the hypothetical, but I will.
I think that that's the important question in this case. Let's just assume you're dead wrong. How do we get to that result? Does
Good
every
question.
single person that is affected by this EO have to bring their own suit? Are there alternatives? How long does it take? How do we get to the result that there is a single rule of citizenship that is the rule that we've historically applied rather than the rule that the EO would have us do?
Rule 23 would be one natural path, assuming that a class could be certified, which we might dispute in this particular case.
Well, you might dispute it, and I think the question is there a class that's just all children of people who have entered illegally? Is that an appropriate class? Can the same thing be done under Rule 23? Or are you going to tell me that, no, Rule 23 has lots of requirements, and you'll never be able to certify a class like that?
Rule 23 provides the equitable tools subject to rigorous criteria, appropriately rigorous criteria, to obtain that kind of class-wide and
That suggests to me you're going to be standing.
So exactly, she is calling out this person's behavior because this dipshit has come before the court and lied and been disingenuous before. She knows what to expect, and good on her for calling him out, because what he's saying here is, if we do it our way, there will be these forms of relief. There will be these things. You can go to Rule 23, which I don't even fucking know. I don't care. You can go to Rule 23. You can do this stuff. The logical argument, I can look up what Rule 23 is, and I care about the functioning of our government. But the real argument here is, he is saying there's a remedy, similar to how he did in Trump 2020. In the Trump v. United States case. He is saying that there's a remedy, but she is calling him out. If we did it your way, you would most likely be here fighting that remedy. Even the way he talks about it now. He has probably couched his speech a little bit from the last time where he straight up fucking lied. This time, he is a little bit more, oh, well, there are rigorous criteria, and it sounds like the very relief that I'm saying, if you're dead wrong on this, what would be the relief? You say Rule 23, you would be the person arguing against that Rule 23 being used for these people, because that's what you've done before. You've done exactly that before, you disingenuous piece of shit.
Ending up here in the next case saying that Rule 23 is inapt for this circumstance with this number of people, maybe with some questions that are individual, who knows. So let's put Rule 23 aside, because I got to tell you that does not fill me with great confidence. How else are we going to get to the right result here, which is on my assumption that the EO is illegal?
That would be a profoundly wrong result, but I think what I would offer is that, very similar to Labrador against Poe, what the court should be engaging here is a balancing of the equitable factors as to the scope of remedial relief, not as to the underlying merits. And our contention that this exceeds the traditional scope of equity that's reflected in the 1789 Judiciary Act, we're overwhelmingly likely to succeed on those merits for all the reasons that are stated in our
Yes,
briefs.
I mean, that's a lot of words, and I don't have an answer for if one thinks. And, look, there are all kinds of abuses of nationwide injunctions. But I think that the question that this case
She said, you said a whole bunch of shit, but didn't say jack.
presents is that if one thinks that it's quite clear that the EO is illegal, how does one get to that result, in what time frame, on your set of rules, without the possibility of a nationwide injunction?
On this case and on many similar cases, the appropriate way to do it is for there to be multiple lower courts considering it, the appropriate percolation that goes to the lower courts, and then ultimately this court decides the merits in a nationwide.
But you don't listen to this court. The whole thing, it does drive me a little bit wild that we're even listening to arguments before the Supreme Court when the last decision that they made hasn't even been respected.
Binding precedent. You have a complete
Not
inversion
last,
of that
but
through the nationwide
Kim
injunctions.
Arbrego
So, General
Sports.
Sauer, are you really going to answer Justice Kagan by saying there's no way to do this expeditiously?
Well, I'll refer to my former answers. Rule 23 provides the tools to do so. Multiple injunctions.
But you resisted Justice Kagan when she said, could the individual plaintiffs form a class?
That has never been briefed in the court below. I do not concede that we would.
Exactly. So he knows better to lie now. She's calling him out. This is why you lied before. This is why they do it. This is why they lie. When you can get somebody up like a lawyer and he knows better and he doesn't. But they lied. He lied in the last time. He lied and said there would be relief available. And then before the Supreme Court said those lies. And then afterwards went and argued the exact opposite. They are having him here now and they are not allowing. Amy Coney Barrett is the one weighing in to say, hey, by the way, that sounds like a whole bunch of bullshit. It sounds like you're giving us away. We say this needs to be solved expeditiously. We would need to see the way you're doing things would need to be able to be sorted. And he's like, well, it wouldn't. We just send it to court and then we deal with it there. And then I'd probably argue against the main thing I'm saying, that Rule 23. She is ripping this down. Rip this down. These are lies. He is couching it a little bit better. He is being more careful with his language this time. I won't commit to this. I won't commit to that sort of thing. This is a trash person. He's smart enough to know, and he's doing it on purpose.
Version of that through the nationwide injunctions or the district.
So, General
courts.
Sauer, are you really going to answer Justice Kagan by saying there's no way to do this expeditiously?
Well, I'll refer to my former answers. Rule 23 provides the tools to do so. Multiple injunctions.
But you resisted Justice Kagan when she said, could the individual plaintiffs form a class?
So you can't. So refer to Rule 23, but also Rule 23 wouldn't apply to them.
That has never been briefed in the court below. I do not concede that we wouldn't oppose class certification in this particular case. There may be arguments that this case is or
Can't do 23, can't do the class act.
is not appropriate for class certification. And
If there were a class appropriate for class certification, you concede that that could resolve the question quickly?
yes,
You
absolutely.
concede it could resolve the question quickly through precedent?
Yes, absolutely. It could do so. I mean, we obviously dispute the.
So just on that point.
And if the court, sorry to interrupt. Go ahead, please. All right, I got a quick one.
Well, I'm going to say just on that point. So, let's say that we're an individual person even. Let's say it wasn't a class, and goes up and gets a ruling from the Second Circuit that the EO is illegal. Does the government commit to not applying its EO in the entire Second Circuit, or does it say no? We can continue to apply the rule as to everybody else in the Second Circuit.
I can't say as to this individual case. Generally, our practice is to respect circuit precedent within the circuit, but there are
Yes, that
exceptions
is
to that.
generally your practice, and I'm asking whether it would be your practice in this case.
Such a good question. Why are you so mealy-mouthed with something so direct? They were direct. They asked you a question. If you're going to make every individual, if you won't respect giant classes, and you're going to make every individual or small class do this in every single district, will you at least respect these rules? You're making us go in the most pedantic, most stupid way. You are going completely away from the founding documents. You are going completely away from the fucking Constitution. So if we are going to do it your way, if everything goes your way, are you at least going to respect it in the district that you fucking end up losing in? And he won't give a yes to that. So fucking pathetic, but such a good question. Way to go, Kagan.
I can't answer because it would depend on what the lower court decision said. So there are circumstances, as I was suggesting, where we think that we want to continue to litigate that in other district courts in the same circuit as well.
Yeah, so that means it's not even the normal time it takes for everything to get up, through the circuit courts and to the Supreme Court. Because even in those circuits that say that the EO is illegal, you're going to be saying, no, we only commit to saying it's illegal to this one guy who brought the suit.
Article 3 and the court's traditional equitable practices provide a range of tools to address that, including potentially nationwide class action. A nationwide
A
universal
nationwide
injunction is
class
not one of
action,
those
which
tools.
you say you're going to oppose when that gets challenged.
We are like
Exactly. He is offering solutions that he will fight against. Why are you offering them? Arrest this person at this point. He's lying to Supreme Court justices, lying openly in court. Is he on the record or something like that? Because if these aren't lies, the last ones definitely were. I listened to the last oral arguments. The last oral arguments were much worse. He was lying much more. He is very clearly saying that you can go for this type of relief, but then he is going to fight against this relief. At the very least, maybe not arrest, maybe it's something like that, but this is disgusting behavior. And it leads to bad outcomes for people. You are making people not citizens. At the end of the day, this is insane that we're going back and forth on this, but at least you highlight how ridiculous it is.
likely to oppose
When
on
that
the merits.
proposed.
Yes, and if it does not meet the rigorous criteria of class certification, the court should not enter that injunctive relief. That's
Do you think,
feature, not above.
how about you're not willing to commit to abiding by the Second Circuit's precedent suppose that there's a single person who brings a suit, and it gets all the way up to us after 3 or 4 or 5 years. And we say, we really do agree with those 4 precedents that Justice Sotomayor started with, and your EO is illegal. Is that only going to bind the one guy who brought this suit?
No, that would be a nationwide precedent that the government would respect.
So finally,
No, they would not. You cannot. I might not belong here, guys. I just, how can you be so slimy? How can you be so disgusting? How can you be so two-faced? How can you be such a fucking liar with no principles? You sit here representing the executive branch who is currently in defiance of a Supreme Court order. Like, they have ordered the facilitation of the return of somebody wrongfully, admittedly by your own administration, admittedly wrongfully deported, and he is still not here. You are in open defiance of the Supreme Court right now, and you say to them that you would definitely honor it. Lies.
Once it gets to us after 4 years, you're going to respect that.
Yes, and in addition, we may well respect circuit-wide precedent. The Second Circuit, it just is.
And for 4 years, there are going to be like an untold number of people who, according to all the law that this court has ever made, ought to be citizens who are not being treated as such.
And in the meantime, any of those plaintiffs could have come forward and sought, preliminary injunctive relief, and they could do so on a class-wide basis.
And remember, non-citizens don't even get fucking rights anymore. Gilberto Borrego Garcia didn't get his day in court. His one stay that one country he wasn't supposed to go to didn't listen. So these people disrespect courts at every turn. But don't worry, the courts will save you.
There are tools to address this, but the universal injunction, which is issued here 3 days after the executive order was issued, is not one of those tools.
Thank you, counsel. 3 years, 4 years, we've been able to move much more expeditiously. I think we did the TikTok case in a month. Presuming, I gather an important part of your answer is that people can litigate differently, and one will go to Massachusetts, the other one will go to Houston, and you'll get conflicting decisions fairly quickly. And is there any reason why this court, and I gather that's your safety net, is that at the end of the day, however long the day is, this court can issue a decision and it will bind everything else. Is there any reason in this particular litigation that we would be unable to act expeditiously?
Absolutely not, Mr. Chief Justice.
Okay, thank you. Justice Thomas?
General.
So this is the split here. It's right down here. It's the women agree that this is dog shit, and then the men agree with this piece of human garbage. So John Roberts' question there is a bailout from this guy was at a dead end with no, hope. He was drowning, and then John Roberts comes in and says, "Oh, well, actually, it would be pretty quick. We got this one thing done pretty quick." Or the whole thing. One of his initial things that he said is to not have so many things coming up on the emergency docket, and then John Roberts and John Sauer just had a fucking handshake, basically, where they're like, "Oh yeah, but we don't mind putting stuff on the emergency docket if we need to. You have a safety net of the emergency docket." Fuck all of you. You're all garbage. And the people on the left, obviously not Sotomayor, Jackson, Kagan, and Barrett, I'm warming up to you. I'm not even gonna lie.
General, when were the first universal injunctions used?
We believe that the best reading of that is what you said in Trump against Hawaii, which is that Wirtz in 1963 was really the first universal injunction.
You see how they're just bouncing things off each other? Did they trade fucking notes? You goddamn losers.
There's a dispute about Perkins against Lupin's Oil going back to 1940, and of course we point to the court's opinion that reversed that universal injunction issued by the D.C. Circuit and said it's profoundly wrong. Now, if you look at the cases that the either party cite, you see a common theme. The cases that we cite, like National Treasury's Employment Union, Perkins against Lupin's Oil, Frothingham in Massachusetts against Mellon, going back to Scott against Donald, and all of those are cases where the court considered and addressed the sort of universal, in that case statewide, issue of provision of injunctive relief. So when the court has considered and addressed this, it has consistently said you have to limit the remedy to the plaintiffs who are appearing in court and complaining of that remedy.
So we survived until the 1960s without universal injunctions.
That's exactly correct. And in fact, those are very limited, very rare, even in the 1960s. It really exploded in 2007 in our cert petition in Summers against Rhode Island Institute. We pointed out that the Ninth Circuit had started doing this in a whole bunch of cases involving environmental claims.
Justice Alito?
You began by outlining what you...
See, these are just glaze fests, dude. Like, hate to be a fucking Gen Zer about it, but you're literally just
see
glazing,
as
bro.
practical
Just
problems
fucking
that have been
nuts.
created
Gross.
by universal injunctions. If we were to hold that the states have standing, and if it is possible for a plaintiff to get emergency certification of a class, would we, suppose we agreed with you on universal injunctions, but allowed those other two avenues, would the practical problem be rectified to any substantial degree?
Certainly, if there were an injunction that extended to all of the litigating states, that would cover a very substantial portion of the country, and also an emergency sort of class certification decision might also grant very broad relief.
So the answer is that the practical problem would not be solved. And if that's the case, what is the point of this argument about universal injunctions?
I think the point is that universal injunctions exceed traditional principles of Article 3, and they exceed the traditional equitable authority, and that's what yields all these sort of pathologies, so to speak, of the current practice of issuing them very, very easily.
Thank you.
Justice Sotomayor?
You answered Justice Gorsuch, I think correctly, that if Article 3 precludes universal injunctions, then even class actions are illegal. That's what you're arguing, isn't it?
I disagree with that profoundly.
How could it, if Article 3 and only prohibits injunctions that affect non-members or non-plaintiffs, how could Congress give a remedy like a class action?
In an article, or in a Rule 23 class, every represented member of the class has standing by hypothesis. So every single one of them has an Article 3 injury, and Rule 23 again.
So that would be the only method.
It would be very similar to the Bill of Peace, where all those parties, either president or
shouldn't-
representative capacity, are bound.
We can act quickly. If we are worried about those thousands of children who are going to be born without citizenship papers that could render them stateless in some places because some of their parents' homes don't recognize children of their nationals unless those children are born in their countries, they're not going to be receiving federal benefits because that's the claim of the plaintiffs here, that they, or the state plaintiffs, that they're not going to be able to provide services to those children. Shouldn't we grant cert before judgment on that issue? If we're afraid that this is, or even have a thought that this is unlawful executive action, that it is Congress who decides citizenship, not the executive, if we believe, some of us were to believe that, why should we permit those countless others to be subject to what we think is an unlawful executive action, as unlawful as an executive taking the guns away from every citizen?
Cert before judgment would be another tool through which this court could act expeditiously.
Is this the kind of case where the equities would call for that? And why wouldn't it? It's a pure legal question. What does the Constitution mean with respect to citizenship? There are no individual facts that would alter our conclusion. If we can't do it by a universal injunction, because you say Article 3 doesn't permit that, Article 3 wouldn't permit us to give a universal injunction, even if we rule. Why don't we grant cert before judgment, so that all of these parents would have a firm Supreme Court decision that they can take where? Because you're saying nobody can grant a universal injunction.
No party has asked for that in this case, and I think one reason is that would deny the court of the benefit of percolation in multiple lower courts of a novel and
Right
sensitive
now,
and
we have
important
multiple
constitutional
courts.
question.
We have novel courts who've percolated this issue and said, you're violating precedent. Not only precedent, but the plain meaning of the 14th of the Constitution.
Respectfully, I think what we have are lower courts making snap judgments on the merits that ignore the fundamental principle of the 14th Amendment, that it was about giving citizenship to the children of slaves, not to the children of illegal immigrants who really were not even a very discreet class at that time.
And
that's
there
the
were
sort of
some
argument that
people in
deserves percolation.
Congress who argued against the 13th Amendment just because of that. Some people who argued against passing the amendment just because of that, because it would give citizenship to gypsies.
I think the relevant history of the 14th.
But it still got passed. That's the most important thing. This frustrates me. I don't know if I'll be able to finish this today. It frustrates the absolute shit out of me because, god damn it. Like, let's listen to that part again.
On the merits that ignore the fundamental principle of the 14th Amendment, that it was about giving citizenship to the children of slaves, not.
Because she brings up a really good point here. It's like, yeah, the time to litigate this, the time for these arguments isn't after it's been made a law or do whatever. If you really want this, you have Congress, you have Senate, you have the House. Get a fucking majority, get something that you would need to make a big change or something like that. Or if you can't do it. Breaking the law this way and then just having the argument with the Supreme Court after the fact is fucking insane. But always remember, at the end of the day, any of the justices that voted for the Trump v. United States verdict can say nothing about this. Amy Coney Barrett can say nothing about this. All this shit, breaking the law, taking citizenship away from people, using SEAL Team 6 to assassinate a political rival, all this stuff is immune from criminal prosecution ever. The way it's written, there is no way to conduct that investigation. There is no way to have that prosecution. There is no way to seek legal remedy. Other remedies are required.
To the children of illegal immigrants who really were not even a very discreet class at that time.
And there were some people in Congress who argued against the 13th Amendment just because of that.
Yep. They
Some
argued it
people
in
who argued
Congress,
against
the one
passing
place
the
where it was
amendment
supposed to
just
happen,
because of that,
and then
'cause
they
it would
passed
give
it. Anyway,
citizenship to
fuck you.
gypsies.
I think the relevant history of the 14th Amendment is the statements of Senator Trumbull, who emphasized that domicile was the key criteria, and he said that in a letter to Andrew Jackson. We've
And
cited in
got
our Ninth Circuit
rejected,
briefing a
and
host
it
of
got
decisions that back that up.
rejected repeatedly. We can go into the history of citizenship, but I still go back to my question. You claim that there is absolutely no constitutional way to stop, put this aside, to stop a president from an unconstitutional act, a clearly, indisputably unconstitutional act.
Yep. Directly against the text of the Constitution. You are saying that we don't have the remedy. But it's just like Trump v. United States. The 5 men are going to give in on this, it sounds like.
Taking every gun from every citizen. We couldn't stop that.
I disagree with that for the reasons I've said, including the equitable tools.
No, because you said to us we'd have to wait until there was a final judgment. You're not sure you would respect the judgment of every circuit. You're not sure that you would respect even a final judgment of the Supreme Court, because it only binds the parties before it. And if there's no class action, that only binds the parties before the court.
I don't think there's a, so to speak, really unconstitutional exception to the strictures of Article 3 or the scope of equitable authority, and the court should not recognize one, because what we see, not just in this case, but in the 39 others, is that the district courts who issue these injunctions all passionately disagree with the thing that's being challenged in that. So that principle that, well, this we think is really unconstitutional, therefore we should ignore the general principles of Article 3 is not a principle the court ought to adopt.
Justice Kagan?
So, General, on this question of expedition, I mean,
Just gotta pause it real quick, see if there's been a decision. I don't think there has been, though. No clear decision yet. At least what I'm seeing.
it sort of depends on the government's own actions in a case like this one, where one can expect that there is not going to be a great deal of disagreement among the lower courts. I mean, let's assume that you lose in the lower courts pretty uniformly, as you have been losing on this issue.
God, I love that she brings that up. You have been losing. You're losing on this issue. You're saying once we get here, nothing that he says is consistent. He wants this, he wants that, he wants this, he wants that, but it's all flip-flopping. He just wants everything his way. And this is what it sounds like when you're defending positions that are dog shit.
And that you never take this question to us. I mean, I noticed that you didn't take the substantive question to us. You only took the nationwide injunction question to us. I mean, why would you take the substantive question to us? You're losing a bunch of cases, this guy over here, this woman over here, you know, they'll have to be treated as citizens, but nobody else will. Why would you ever take this case to us?
Well, in this particular case, we have deliberately not presented the merits to this court on the question of the scope of remedies, because, of course, that makes it a clean vehicle where the court doesn't have to look at the past.
You're ignoring the import of my question. I'm suggesting that in a case in which the government is losing constantly, there's nobody else who's going to appeal, they're winning. It's up to you to decide whether to take this case to us. If I were in your shoes, there is no way I'd approach the Supreme Court with this case. So you just keep on losing in the lower courts, and what's supposed to happen to prevent that?
Again, I respectfully disagree with that forecast of the merits, but in response to the question, what I would say is we have an adversarial system, and if the government is not, for example, not respecting circuit precedent on the court's hypothetical in the Second Circuit, someone injured in the Second Circuit could take the case up, and they could say, look, the government is violating circuit precedent on the hypothetical multiple circuits.
That's the case we're going to take? Somebody who says, you know, after we've said that this all has to be done one by one by one, then we're going to take a case from somebody who objects to proceeding one by one by one?
Remember, at the start of this, Kagan, so good, bringing up the nonsensical nature of his argument. Remember, one of the things he said was he doesn't want to burden the courts with more bullshit. And then everything he suggests burdens the court with more bullshit. And John Roberts jacks him off for it. Oh, well, we could get that done. We got the TikTok thing done pretty quick. Fucking, you are the worst.
I'm not sure I understand the question. I understood the hypothetical.
If you win this...
And then doesn't understand the question. This is the conservative. If you ever hear a conservative, any friend, anybody, if they ever say this, they remember fucking everything. they would say something
You know,
different.
after
if
we
they say,
said that,
"Oh,
that
well,
this all has to be done
I don't
one
think
by
I
one by
understand.
one,
I
then
don't
we're
know
going
what
to
they're
take
talking
a
about."
case from somebody
They are a
who
fucking liar.
objects
They're
to
pretending they don't
proceeding
understand.
one
They're
by
playing
one by one.
stupid.
I'm not sure I understand the question. I understand the
If
hypothetical.
you
I'm not
win
sure I understand. I'm not sure I understand the question.
this challenge and say there is no nationwide injunction and it all has to be through individual cases, then I can't see how an individual who is not, you know, being treated equivalently to the individual who brought the case would have any ability to bring the substantive question to us.
They would bring a lawsuit in the federal district courts against the government for an injunction protecting them. And if the government wasn't respecting, you know, on the
Yeah,
hypothetical circuit
and then
precedent-
they win. And again, I mean, you need somebody to lose, but nobody's going to lose in this case. It's just you're going to have like individual by individual by individual, and all of those individuals are going to win. And the ones who can't afford to go to court, they're the ones who are going to lose.
The tools that are provided to address hypotheticals like this, again,
This is not a hypothetical. This is happening out there, right? Every court has ruled against you.
we've only had snap judgments on the merits. You know,
Listen to what was said. Every court has ruled against you, and he says those are snap judgments. He knows he's in the wrong. He knows he's been ruled against. Those are snap judgment. What does that mean? You are disrespecting the decisions of the lower court to the face of the Supreme Court.
obviously, we're fully briefing the merits in the courts of appeals, and our arguments are compelling. More fundamentally, in
I'm
response to the question,
suggesting to you, like the real brunt of my question is, in a case like this, the government has no incentive to bring this case to the Supreme Court because it's not really losing anything. It's losing a lot of individual cases, which still allow it to enforce its EO against the vast majority of people to whom it applies.
and again, Rule 23 provides an avenue to address those very concerns.
Thank you.
What is Rule 23? Let's see. Because he's relying on it quite a bit, and then everybody's like, oh, like, will it apply? Will it apply? Governs class actions in federal court outlining the requirements for certifying, maintaining a lawsuit on behalf of a group of people who share a common interest. Essentially, it allows for a single lawsuit to represent claims of many individuals, provided certain conditions are met. All right, we're going to have to read up on that a separate time.
Justice Gorsuch?
Well, Justice Kagan asked my questions better than I could have. How do you suggest we reach this case on the merits expeditiously?
There's a number of tools the court could do that. We think this case is one that cries out for percolation, that the court should allow the lower courts to address the merits issue multiple times. It's currently on briefing in 3 different cases in the First, Fourth, and Ninth Circuit.
And you're going to lose all of them.
And we think that that's the appropriate way to do it. If the court disagreed, obviously,
When you
court
lose one of
judgments.
those, do you intend to seek cert?
If we lose, yes, absolutely.
Justice Kavanaugh?
So the technical problem here seems to be class-wide relief without the district.
This is a non-serious person. Not just because he's a rapist, but because he's also a piece of human shit. Allegedly a rapist, by the way. Allegedly. And just so we know, why would I ever have to listen to what a court says if the executive doesn't have to listen to what the Supreme Court says? Where is Kilmar Abrego Garcia? Say a court called me in and said I had to appear on a stand. Can I just say, where is Kilmar Abrego Garcia? If the Supreme Court asked me to testify before them, can I just say, well, fuck you, because that's what we do now? Is that the standard practice? Mind you, all of this is possible because dipshits like this said that they would never overturn precedent, that they went and did, and then made terrible decisions like Trump v. United States.
Courts going through the steps to assess whether a class should be certified, correct?
Correct.
Okay. And if you win here on this procedural point, it seems very likely that the day after, there are going to be suits filed all over the place seeking class-wide treatment, maybe statewide classes, circuit-wide classes, maybe nationwide classes. I'm sure they're being prepared now, right? And on what basis would you oppose a statewide class?
I could imagine certain bases, and again, we haven't briefed this in the lower courts yet.
You've been promising everyone here that Rule 23 is the cure-all, and I want to explore on what basis you would oppose a statewide class. Just take that one for now.
For example, and again, this is very hypothetical because I'm not predicting that we will or will not oppose that. We haven't taken a position on that yet.
If you were to oppose it, on what basis would you plausibly oppose it.
There may be problems of commonality and typicality, for example. For example, there's two different sets of groups that are affected by the executive order. There are those where the mothers are temporarily present and those where the mother are illegally present. And in both cases, the father is neither a citizen nor a lawful permanent resident. So there might be issues of typicality. Adequacy of representation might very well be an issue. So there would have to be that rigorous application of those criteria. Now, the argument may be this is a case that is a natural candidate for a Rule 23b2 certification. That may well be true. The government hasn't taken a position on that. Our position is not that class certification will necessarily be granted. Our position is that Rule 23 is how these sorts of claims should be channeled.
And you think, I think you just said, it's very possible that class certification may be granted.
It is possible. We don't know yet because there was a class certification motion filed at the very beginning in Western District of Washington, and it was just never briefed because obviously the pathology here is that the nationwide injunctions just go blowing past the class certification procedures.
And I guess...
As they should. If something is directly unconstitutional, it probably should apply to the whole fucking nation. It probably should be a sweeping thing and not just an individual by individual basis. The injunction part, the nationwide injunction part, is important because it is such a fundamental part of the whole fucking country all at once. Yes.
Rule 23b2, for a lot of the cases we've had over the past 25 years that you talk about where there have been universal injunctions or where the lower courts have had that, I mean, 23b2 could been used in a lot of those, presumably, correct? Eviction moratorium, student loans, OSHA vaccine mandate. Do you see the possibility that 23b2 could have been used instead of, I mean, some of those were APA, but put aside the APA issue for now.
Yeah, we do set aside that issue, if I may.
I got it.
But yes, I agree with that as to some, but not of the other cases. It's hard to see how, for example, Biden against Nebraska, where a state was the plaintiff, might have been a 23b2 class. And the Alabama Association of Realtors might have been a much better candidate for that. And again, not taking a position on the individual merits. Our overarching point is there's a tradition of equity in this country that goes back to the English Court of Chancery, and what's happening in these universal injunctions, again, 40 times in this administration, at least 22 times in the last administration, 64 times in the administration before that, is just disregarding those appropriate procedures to seek this kind of global relief.
I want to ask one thing about something in your brief. You said, quote, and of course this court's decisions constitute controlling precedent throughout the nation. If this court were to hold a challenged statute or policy unconstitutional, the government could not successfully enforce it against anyone, party or not, in light of stare decisis, end quote. You agree with that?
Yes, we do.
Okay. If you...
It's crazy that you can say that. Why isn't anybody bringing it? I know it's not what's before the court and stuff like that, but it's insane. Camara Abrego Garcia.
Prevail here, the original executive order had a 30-day period before it took effect. If you prevail here, should there be any pause so that things can happen that need to happen for 30 days or some period of time, or should we not even worry about that?
Yes, we can see that the 30-day ramp-up period that the executive order itself calls for never started because the universal TROs were entered almost immediately, and we don't dispute that there should be a 30-day ramp-up period. For another reason as well, which is that we've been enjoined from even doing guidance, even formulating a policy, and that itself is another problem with these injunctions.
As you well should. What if the policy was to fucking murder people? What if the policy was some racist shit? Yeah, you probably shouldn't be able to plan that, plot that, figure that out, give certain assignments and do all that shit. Yes, we should probably have some way of stopping you right at the beginning, and this is one of those things. It's so clearly enshrined in the Constitution. Why the fuck? I hate them. I hate them all. I hate them so much.
On the day after it goes into effect, it's just a very practical question how this is going to work. What do hospitals do with a newborn? What do states do with a newborn?
I don't think they do anything different. What the executive order says in Section 2 is that federal officials do not accept documents that have the wrong designation of citizenship from people who are subject to the executive order.
How are they going to know that?
The states can continue to, the federal officials will have to figure that out.
How?
So you can imagine
the federal officials will have to figure that out.
A number of ways that...
There are a number of ways that we haven't figured out.
The federal officials could.
Such as?
Such as they could require a showing of, documentation showing legal presence in the country. For a temporary visitor, for example, they could see whether they're on a B1 visa, which would exclude kind of the birthright citizenship and that kind of.
For all the newborns? Is that how that's going to work?
Again, we don't know because the agencies were never given the opportunity to formulate the guidance. They would have 30
They're only going to have 30 days to do this. Do you think they can get it together in time?
They're under. That's what the executive order instructs them to do, and hopefully they will do so. Again, it's a speculative and hypothetical scenario because they were enjoined from even starting that process.
And then last question. You mentioned before this has come up in the last 4 or 5 administrations primarily. I guess I've thought about that a lot too. Why? It seems why might be it's harder to get legislation through Congress, particularly with the filibuster rule. Presidents want to get things done with good intentions. The executive branches that work for those presidents push hard to, when they can't get new authority, to stretch or use existing authority. And they've been pushing, understandably, all with good intentions, all the presidents, both parties, right, with good intentions to push.
Fuck you.
Is that your understanding of why this has happened more, that there's less ability to get legislation? Because I'm trying to figure out the why to your opening about the last 4 or 5 administrations. I agree with it. I think that might be the why, but I'm curious what you think.
I'm speculating about the motivations of the individual district judges who grant these, but one
Literally
explanation might be,
having, like,
this
a
is an extraordinary
chat.
power. It's a very strong power for the reasons the questions have reflected.
Well,
for a district
let me
judge
just
who-
pause you right there. The underlying point is that these district judges are not just doing universal injunctions. They're finding these actions illegal.
Exactly. They're illegal and unconstitutional. Stop saying that they're making snap judgments and then saying it to the Supreme Court. It's insane that you can
Because they're
that you can
exceeding
disrespect it so
authority.
blatantly.
And oftentimes we are too, when it gets to us, finding the actions of presidents of both parties unlawful because they exceed existing authority. So is that coming up more often because of, why is that coming up more often?
You know, it's hard to do an historical analysis, but I would draw an analogy to the New Deal. And Professor Bray makes this point in his article, that actually there were very, very passionate challenges to, you know, sort of nationwide policies during the Roosevelt administration, and they were not addressed by issuing universal injunctions. He cites an example where in one case, a policy had been held illegal, and there were like 1,600 injunctions against that policy, all protecting the individual plaintiffs. So if you look at the history, it's not clear that what we have of, you know, disagreement, but difficulty, gridlock, getting things through Congress and so forth, that's not necessarily new. What is new, and is certainly unique to the last 5 presidential administrations, is having these given on this widespread basis and this systematic basis, 40 again in the last 4 months.
Thank you.
Justice Barrett?
General Sauer, I want to ask you about a potential tension. Well, no, not potential tension, an actual tension that I see in answers that you gave to Justice Kavanaugh and Justice Kagan.
Let's go, Amy. Rip them up.
You resisted Justice Kagan when she asked you whether the government would obey within the Second Circuit a precedent. I'm distinguishing between opinions and judgments here. Did I understand you correctly to tell Justice Kagan that the government wanted to reserve its right to maybe not follow a Second Circuit precedent, say, in New York, because you might disagree with the opinion?
Our general practice is to respect those precedents, but there are circumstances when it is not a categorical practice, and that is not
This
a new policy.
administration's practice or the longstanding practice of the federal government? And I'm not talking about in the Fourth Circuit, are you going to respect a Second Circuit? I'm talking about within the Second Circuit. And can you say, is that this administration's practice or a longstanding one?
As I understand it, longstanding
Really?
policy of the Department of Justice, yes, that we generally, as it was phrased to me, generally respect circuit precedent, but not necessarily in every case. And some examples might be a situation where we're litigating to try and get that circuit precedent overruled and so forth.
Well, okay, so I'm not talking about a situation in which, you know, the Second Circuit has a case from 1955 and you think it's time for it to be challenged. That's not what I'm talking about. I'm talking about in this kind of situation. I'm talking about this.
I'm talking about the shit we're talking about right now. I hate that they can do so much to intentionally misunderstand. I'm glad that we're
week, the
finally
Second
dragging
Circuit
these people
holds
over the
that the
coals
executive
for it.
order is unconstitutional, and then what do you do the next day or the next week?
Generally, we follow
So
those.
you're still saying generally?
Yes.
And you still think that it's generally the policy, longstanding policy of the federal government to take that approach?
That is my understanding.
Okay, so, but it sounds to me like you accept a Cooper versus Aaron kind of situation for the Supreme Court, but not for, say, the Second Circuit. Like
I would
where
say
you would
it's-
respect the opinions and the judgments of the Supreme Court, and you're saying you would respect the judgment, but not necessarily the opinion of a lower court.
And again, I think in the vast majority of instances, our practice has been to respect the opinion as well, in the circuits as well, but my understanding is that has not been a categorical practice in the way respect for the precedents and the judgments of the Supreme Court has been.
So you're not hedging at all with respect to the precedent of this court?
That is correct. I believe the quotation from our application directly
Okay.
addresses that, and we stand by that completely.
Okay. Next question. So this is also a follow-up to some of the questions that others have asked you about the merits of the order not being before us. Did I understand your answer to be because you think percolation is really important for this one?
We do think percolation is really important for this one, but the reason the merits are not before is because we've only submitted a stay application on the scope of relief question, and as Labrador against Poe indicates, the scope of relief is a separate question for the
Oh, I understand it's a separate question, but there are plenty of times that the government comes to us and asks for both.
Absolutely. For example, recently in the Wilkins and Cox application, we did exactly
And
that.
the reason why you didn't ask for both here is because you think that the merits question needs percolation.
Yes, but also more fundamentally, it illustrates that the very problem with these nationwide injunctions is they force this rushed, fast and furious.
they keep saying this, rush decision, stuff like that. You're not arguing on the merits. You're not. You are jumping right past them, and this is just like the immunity thing. You're not arguing that you didn't even steal the election. You were just saying we should be able to.
Decisions on the merits. So I think it'd be very inappropriate in this case to come to a stay application saying, please give us a rushed, decision on the merits of something that's very
But
complex.
the government's done that in other cases too, right?
Those cases would be different. In this case, the example I gave earlier, we think it's very clear cut on the merits. This one is, we concede a novel and
So
sensitive
this one isn't
question.
clear cut on the merits.
This one, in this case, we want the court to address the remedial issue. If we offer the merit first, that's a vehicle problem because the court has, in many cases, just addressed the merits and not the remedial issue. And it's imperative from the federal government's perspective that the remedial question be addressed.
Okay, so last question is about why that is. Justice Alito asked you, well, what's the point of this? If the same thing could happen, which is effectively the EO being enjoined everywhere via class action or because it's necessary to provide complete relief, say, to the states, is there any difference in your view between, say, a class is certified of all individual plaintiffs and they win, and the executive order class-wide, there's a judgment saying that it can't be enforced? Do you want to say, follow up, is there any practical distinction you see? Why does the government care? Is it just the rigors of the certification process, or is it something more?
The rigors of the certification process. Keep in mind that in many of these cases, we successfully oppose class action.
Let's assume, I think, you can't successfully oppose it here for individual plaintiffs.
Well, that opportunity to have our day in court on that is very, very important.
I understand, but let's assume, go with my assumption.
Assuming that we were to lose
Assume the class is certified. Is there any benefit? If a class is certified, and let's say, you were pointing out that the executive order targets two different kinds of people. Let's assume that it's commonality because, they only target one portion of the order, right? In that circumstance, does the government get anything different? This is back to Justice Alito's question about what's it to you? What's the practical difference to you? Do you want to say anything about whether there's a practical difference between a universal injunction and a loss in the class?
Absolutely. Okay. Among many others, the represented class members are bound in the class action context. And that means that if they lose, they're bound by that as well. And so they're taking a grave risk, so to speak, by proceeding through a class action. And it has this symmetry where the government is bound if we lose, they are bound if we don't lose. And that's a very, very important distinction.
And you would respect that judgment?
If it were a judgment. Now we may try to litigate in other contexts to try and get a different judgment.
Oh my God, so fucking disgusting. You can't even say it there. So we want to be able to do this. We want to be able to, try these people. They have to bring a class action against us. They have to identify themselves and do all this stuff, not have a judge say that the attacking of them is that. So you want to jump past a part of the Constitution. Why should we let you jump past a part of the Constitution to put these people through this in order for them to beat you or not beat you? And then the benefit being, we have them rounded up. They're in this class action, so they'll have to answer to it. Why would they fucking listen if you were saying right now, you're saying this group of people would be in the class action? We'd have them in this group, and then they'd be bound by it. So would we. You were not saying you were bound by it. You were saying that you wouldn't follow the decision. You're even saying that you wouldn't follow the second district if it was going to make theirs. So the Supreme Court, you are in open defiance of. How can you say this? You want to get your day, you want to have your day in court, you want to do whatever. At the end of the day, you don't even respect the court's decision. This is why you don't play. This is where I started the stream. This is what I said. You don't play with a cheater. Once you get to a position where you're ahead of the cheater, you don't play in a fair game against somebody who cheats, because if you get the upper hand, then they're going to cheat so fucking hard that they're going to win. They're going to throw the board. They're going to do something. This is what we're expecting. These people don't listen to the Supreme Court decisions. Why the fuck would they in the future? And it's so barefaced that just a lie of, we absolutely would. Unless, of course, we felt it was. So you get to try over and over and over again on these people, but if they lose once, it's just so. This government is, the way they're trying to set up the government is against the people. The government is for and by the people. It's insane.
Sure, district court, but we would be bound by that judgment, as would they, and that's the crucial point.
Okay.
Justice Jackson?
So as far as I can tell, your bottom line seems to be that what you call universal injunctions give relief to non-parties without going through the necessary steps, which you identify in Rule 23. Do I have that right? Is that sort of boiled to bare essence what you're saying?
I would say there's a lot more to it, but that's one very important point.
That's a key point that I want to focus in on for a moment. I guess I don't understand why you are saying that these kinds of injunctions are giving relief to non-parties. First of all, I think they can be also easily characterized as focusing only on the defendant pursuant to the court's personal jurisdiction over this person relative to the subject matter jurisdiction that the court has, and the relief is telling the defendant, stop doing this thing that the court has found to be unlawful. So rather than characterizing it as a quote-unquote universal injunction, I think one could easily expect to this plaintiff. Am I mischaracterizing? I don't understand where this idea of universal injunctions comes from in this context.
I think the relevant distinction is an order that orders, in this case, the government defendant to cease allegedly unlawful activity as to the parties who have come into court and sued, and one that says to the government defendant, cease the allegedly lawful activity against everyone in the entire world.
No, just cease it. Just stop. This thing, this executive order, I mean, we do this in the APA context all the time, right? The statute says you hold that you set aside the conduct, right? That it's unlawful. And we don't really parse it out and say, okay, but it's unlawful only as it applies to the plaintiff or not. So it's a very common concept for the court to enjoin a defendant.
I guarantee you, this is me. I haven't pre-watched this or anything like that. This is going to be, I don't understand the question, or I don't understand.
From doing particular unlawful behavior. And what you're now asking us to do is to require that the court have an additional limitation in its order that says you only have to stop doing this with respect to the plaintiff. And that's the part that I don't understand. I guess, from what I can read from your papers and what you've said here, that limitation you say comes from this principle that if you don't do that, you would be somehow giving relief to non-parties. But I wonder if that's right. I mean, it seems to me that the relief is the judgment that you provide to the plaintiff that says stop doing this conduct. And you give it only to the plaintiff. That's where the limitation comes. The plaintiff is the only person who can go to court after you violate this order and enforce it. Other people are incidental beneficiaries of a court ordering you to follow the law.
This is like this is the analogy that he used before. It's the company not being allowed to spew toxic waste. Because there are other people affected beneficially by it, it doesn't mean that you can't have it. He even used this, and this seems like a one-to-one. Yeah, we are stopping the bad activity, we are stopping the pollution, and the company that is doing it, yes, the individual plaintiff will receive some relief. We're not saying give money to people who weren't in court that day or some other thing, but they will receive the benefits of you not spewing shit into my community.
That's like everyone in the world. When the court says follow the law, anybody who would have been hurt by your not following the law benefits. Okay, I don't understand why that would limit the court in its ability to tell you don't do this unlawful conduct.
Two responses to that.
Yes.
There's a lot there. Two responses to that. One is that principle that your question referred to is the whole
There's a lot there.
of the court in Worth against Selden, and it's reaffirmed in Gill against Whitford, in Lewis against Casey, and similar cases, that the authority of the federal court, whether it's viewed as arising under Article 3 or under its traditional scope of equitable authority, is to remediate the injuries to the complaining party. And then to address your question about...
Can I just stop you there? I'm, as the court, remediating the injury by telling the defendant to stop doing this behavior. The plaintiff has brought a claim that this executive order is unlawful.
Is illegal, yeah.
I look at it, I litigate it, and I say you're right.
Yes, it is illegal, so stop the illegal behavior.
Stop doing it. You cannot enforce this order. So I don't understand why that's like outside the...
She put it together. The universal injunction thing, it's not the court saying something that's so insane. It's because you are trying to attack everyone in the country at once and their citizenship. You are trying to attack everybody. The reason why the injunction feels universal to you is because you're attacking the fucking universe. You're going after everyone all at once. You're not going after a specific state. You're not going after a specific thing. You are saying anyone who's not a citizen or anyone that we're going to change the citizenship thing, we're going to do this thing too. So you're applying it universally. And then when it gets shut down, you are saying, oh, well, this is universal injunction. And so the courts have gone too far. She put the pin right. This is perfect. She nailed on the head for Justice Jackson here, because this is so good. The only reason the scope feels so large for you is because your executive, your DOJ, has chosen to make the scope quite this large. It's the same argument when people say, oh, well, Trump got charged more than anybody else has, or Trump got pursued by or prosecuted more than anybody else has. What would you expect if you broke the law more than anybody else? Ask that question. If you ever hear that, ask them right back. Okay, so you're saying that Trump went to jail or had people trying to hang him up, the prosecutions, the injunctions, whatever it may be. You're saying that the legal action taken against him is too much. Say it's 50 times, and it was only done to Biden 25 times. My question to you is, say you have somebody who stole 25 times, and you had somebody who stole 10,000 fucking times. what would you expect their punishments to be? What would you expect when they went into court all the different times that they did for all that stealing? Would you expect these two people to be treated exactly the same? If somebody stole 25, or say somebody stole 2 fucking things. Let's do it like that. Went into court once, went into court twice, versus someone who stole 10,000 things and they went to court 3 times. Can that person who stole 10,000 things say, oh, I'm being treated unfairly. This is lawfare. I had 3 courts. He only had 2. That is Trump. That is you maggot, dirty pieces of human garbage. Like, you are saying that you deserve special treatment because you are saying that you're being persecuted. You are saying that it is unright. You have done unprecedentedly dog shit things, so when we have to do unprecedented things to rein your dog shit back in, you turn around and blame, oh, well, the courts go after him. No, you break the law more than anybody else. You deal with the courts more than anybody else. You go after an entire nation's citizenship law. You can't be surprised when the court goes, hey, you can't do that to the whole nation. Oh, well, it feels kind of weird for a judge to be able to do that. It feels kind of weird for your DOJ, for your executive, to be able to change the Constitution unilaterally. Do you ever think that's a little fucking weird? You don't look at it through that lens because you're fucking blinded by the maggots in front of you. All your little friends tell you what it is. You're so ignorant, it's painful. Yes, he may have had more run-ins with the courts, but only because he broke the fucking law more. What else would you expect?
The scope of Worth versus Selden.
If the court, in that case, is imposing what we've called an indivisible remedy, for example, vacator under the APA, there's a debate about what set-aside means. Assuming it means to vacate, then the remedy that Congress has provided as a condition of its delegation to the agency is if one part of the, if the regulation is unlawful, then the remedy granted, which directly remediates the plaintiff's injury on that hypothetical, is an indivisible remedy that benefits others. Here, in this case, and in all the other 40 cases, we see something totally different.
Yeah, I understand.
It is not necessary to remediate the injuries of the plaintiff before them. That is the
I understand. Let me just turn your attention to one other thing, because the real concern, I think, is that your argument seems to turn our justice system, in my view at least, into a catch-me-if-you-can kind of regime from the standpoint of the executive, where every...
Yes, exactly. Stop me where you can, and then I'll get away with a bunch of shit in the meantime. Yes.
Everybody has to have a lawyer and file a lawsuit in order for the government to stop violating people's rights. Justice Kagan says, let's assume, for the purpose of this, that you're wrong about the merits, that the government is not allowed to do this under the Constitution, and yet it seems to me that your argument says we get to keep on doing it until everyone who is potentially harmed by it figures out how to file a lawsuit, hire a lawyer, etc. And I don't understand how that is remotely consistent with the rule of law.
It's not consistent with the rule of law, and it's not internally consistent with his own arguments of not trying to burden the courts. That was what he said. It was one of the first things he said.
A system, and I appreciate that you go back to English common law and the Chancery Court, but they had a different system. The fact that courts back in English Chancery couldn't enjoin the king, I think, is not analogous or indicative of what courts can do in our system, where the king, quote unquote, the executive, is supposed to be bound by the law.
Yes.
And the court has the power to say what the law is. And so one would think that the court could say, this conduct is unlawful and you have to stop doing it.
I think the catch-me-if-you-can problem operates in the opposite direction, where we have the government racing from jurisdiction to jurisdiction, having to sort of clear the table in order to implement a new policy. A great example of this is in the Schilling litigation.
Yes, you do have to make sure your policies are lawful before you enact them. Yes. If it sounds like it's supposed to be a little bit of a pain in the ass, it probably is. You fucking idiot. You're executing the laws. You should probably show some fucking caution.
The military readiness policy, it was universally enjoined by the DDC. It went up to the DC Circuit. The DC Circuit stayed that injunction to allow that policy to go into effect. And then 1 hour later, a district court on the other side of the country universally...
Can I just ask you one final thing, because this relates to also something that Justice Kagan said. I would think we'd want the system to move as quickly as possible to reach the merits of the issue, and maybe have this court decide whether or not the government is entitled to do this under the law. Wouldn't having universal injunctions actually facilitate that? It seems to me that when the government is completely enjoined from doing the thing it wants to do, it moves quickly to appeal that, to get it to the Supreme Court, and that's actually what we would want. What I worry about is similar to what Justice Kagan points out, is that if the government is saying no lower court can completely enjoin it, it actually means that the government just keeps on doing the purportedly unlawful thing, and it delays the ability for this court to reach the underlying issue.
Yep. Because Like they said before, there is no incentive for the executive to bring it up.
Novel, sensitive constitutional issues is a merit of our system. It is not a bad feature of the system.
Thank you.
Thank you, counsel. Mr. Feigenbaum?
Mr. Chief Justice, and may it please the court. This court should deny the emergency application because this injunction was properly designed.
Let's go, and then this is good guy.
To ensure that the states would get relief for our own Article 3 injuries, as we suffer significant pocketbook and sovereign harms from implementation of this executive order, including from the application of this EO to the 6,000 babies born to New Jersey parents out of state every year. The U.S. prefers alternative approaches for granting that relief, alternatives it never raised in the district court below. But its approach would require citizenship to vary based on the state in which you're born, or even turn on or off when someone crosses state lines, raising serious and unanswered administrability questions, not just for the federal government, but also for the states. And it would offend the text and history of the Citizenship Clause itself. Since the 14th Amendment, our country has never allowed American citizenship to vary based on the state in which someone resides, because the post-Civil War nation wrote into our Constitution that citizens of the United States and of the states would be one and the same without variation across state lines. The U.S. has claimed that Article 3 establishes a bright-line rule barring such injunctions no matter the circumstance, even where the states do need it to meet their own harms, finds no support in this court's cases or in the history of equity. Its argument that a single district court cannot decide birthright citizenship, or that we need more percolation on that question for the nation, overlooks that this court already settled this exact constitutional question 127 years ago, and that this EO is contrary to over a century of executive practice.
Thank you.
Finally, the U.S.'s objection that nationwide PIs have simply become too common in the last few months, a complaint about other injunctions sought by other parties, cannot undermine the extraordinary bases for this one. The states, who regularly come before this court as plaintiff and defendant alike, agree that nationwide relief can be reserved for narrow circumstances, but it was needed here. I welcome this.
Yeah, that's the thing. If they say, like, oh, this unprecedented thing has happened, does that mean if we give the other side, if we give the Trumples that defense, if no one has ever been charged for this, if no one's ever done this thing, if no one's ever had this happen, then you can't, it's unfair to bring courts against them. It's an unfair thing to do. I know that's not actually what they mean. You're being mean to our guy, so fuck you. But if we gave them the good faith assumption that they were actually being truthful and they weren't fucking lying to us, if we actually gave them assumption, okay, so you're saying if you do something so bad that no one has done it before, or at least it hasn't been charged, that you cannot charge it again. So I, President Chris, go and firebomb, I don't know, say I'm a Republican. I just firebomb California, Oregon, Washington State. Let's throw in Colorado. Just firebomb, fuck it, Vegas too, fuck it, just murder them all. Just murder the shit out of it. Like unprecedented, millions die, bam, just boom. In your own country, this whole thing. When they took me to court for that, I could then claim, well, no one's ever been charged like this in America. Well, no one's ever been charged for killing this many people in America. That is their argument. Oh, I killed so many people. You're going to charge me for 5 million people murders at the same time? No one's ever been charged with this before. No one's ever been charged for 5 million murders at once. You're really going to charge? Yeah, dog. No one in the U.S. has ever murdered 5 million of their own people like that. It's a new thing, so we're probably going to see some crazy-ass new shit. You broke the law in unprecedented ways. Expect to see unprecedented shit. Expect to see some consequences, you fucking losers.
This court's questions.
Putting the merits aside, what do you think is the origin of, or at least the pedigree of universal injunctions, particularly the Bill of Peace, if you would discuss that?
Absolutely, Your Honor. So there's two categories of these broad injunctions. So first, although we use the term nationwide injunction, if the nationwide injunction is actually about meeting our harm and the alternatives are not legally or practically workable, then it isn't even a universal injunction, as I know this court's separate writings has used the term, because it's about meeting our own Article 3 injury, which is our basic submission about this case. But we do agree that there's some space for universal relief. We trace it back through the history from the Bill of Peace, through Equity Rule 48, which specifically clarified that in the American equitable tradition, it was not always the case that universal relief would bind the non-parties, even as it might benefit the non-parties, continuing on to the tax collection injunctions in the 19th century, and then continuing on as recently as this court's order in AARP. So I do think they've always been in narrow circumstances. They've never been the reflexive or norm of how relief should be granted in this country, but they have been available. I don't think I need that for my case, but I do think they're available in narrow circumstances.
You say they should be available only in narrow circumstances. Why is that?
Yeah, so I could offer the three that I think make the most sense, but we're mindful of some of the concerns that the United States raises. We are states who've benefited from federal policies. We are states who have our own statutes and policies. So sometimes we are on the other side of the V in cases involving universal relief. So we are sympathetic to some of the concerns the United States has about percolation, about running the table in particular cases. We just don't think that that supports a bright line rule that says they're never available. And we've identified, I think, at least three circumstances where they would make sense to be available. The first would be in cases where the alternative ways of remedying the harm for the parties are not practically or legally workable. That's this case, and I'll return to that in a second. The second would be congressional authorization. So I took my friend on the other side to try to set aside vacatur, but I do think their Article 3 objections would raise serious questions for remedies like vacatur, for remedies like the Hobbs Act. Even the Hobbs Act, which could set a nationwide PI after a multi-circuit lottery, might ultimately have problems under their view of Article 3. And then the third thing I would say is there may be cases in which the alternative forms of getting non-party relief are not legally or practically available. So that might be a case like AARP, or even a case like this one, where district.
Just so we know, we got about 10 more minutes here. I won't have too much time. I got to let off a little bit early. I will be changing up the stream schedule here soon. In the coming weeks, I will be doing more days throughout the week. My work schedule is changing up, so I will be slipping in more stuff. Don't have a day picked out yet, but think similarly afternoons, evenings, probably sliding in and then getting you guys through. I'll probably keep the Saturday show up for a little bit. I may just shorten it like I have been. I've been doing closer to 3 hours, not 4. The big thing there is it just gets late here after the move, so I am getting used to that. But yes, 10 minutes left-ish in this one.
Courts could consider the availability of the class action device, but if it couldn't move fast enough.
And that'll leave us about a perfect hour left on these oral arguments. I don't know if I'll be back on before we actually get a decision on this, but I think we heard the most important parts. Hearing the opposition and how little it stands up, I don't think I necessarily need to hear our guy
Rule
here.
23 doesn't include TROs and
say the stuff I already agree, but I will listen to it in my own time, on my own time. I just think it's very important for you to hear, especially with how that piece of shit argued for Trump v. United States, and the justices being able to call out his lying and his flip-flopping back and forth. He will argue this thing out of one side of his mouth, but then in the next breath, out of the next side of his mouth, he will, not even in the next breath, out of the other side of his mouth. He is such a snake, he can do both at the same time, argue opposite sides of the point, and say, hey, by the way, trust me.
PIs. If it couldn't move fast enough in those contexts, courts might need to step in anyway. But I think we fit in the first bucket in this particular case because the alternative ways of remedying our particular significant pocketbook harms to the tunes of millions of dollars can't be remedied, as the district court found below, without granting us this kind of relief.
Well, I mean, you could benefit through percolation and a decision from this court with reasonable expedition.
So I have no objections to reasonable expedition. We would have no objection to this court even setting supplemental briefing on the merits and hearing the merits directly. I'm happy to talk about the ways in which I think the merits do bear on this emergency application. But more fundamentally to your question, Mr. Chief Justice, I would just note that I don't think the alternatives actually fully remedy our injuries in a couple of different respects. So I heard my friend on the other side to specifically say today that maybe there can be an instruction to the federal government that at least when you're dealing with the plaintiff states, you treat these individuals kind of as though they're citizens, even if they're not really citizens. And that doesn't work, not just for the federal government. I agree, Justice Gorsuch, it may well be that the federal government can decide when to take its own medicine, but I'm talking about administrability burdens on the states, and I'm talking about administrability burdens on third parties as well.
Can I ask you a question about that, counsel? Your three buckets are very thoughtful. The first one seems to me kind of consistent with traditional equity, which is if it's required, if you've got to remedy the plaintiff's harm. That's your point there, and you're saying we fall in that bucket. I get that argument. The second bucket is possibly Article 3, okay? That Congress could authorize, and maybe has authorized circumstances. But that doesn't answer the equity point. So we come to bucket 3. And I'm struggling to understand what the rule is there. You seem to suggest, well, if it's really important, and if you have to act expeditiously, then go ahead. But I think every district court who enters one of these thinks that's what they're doing. So what's the constraint there? If you share the government's concerns about the rise of these things in the last few decades, what teeth does any of that have?
So I do feel like something of an amicus to this question because nothing in my injunction rises or falls on this third bucket. So I'm happy to answer questions.
I need all the amici I can get.
Fair enough, Your Honor. So I would say two things about that. The first is it does require reading the history in a way more like I do, which does not create a single bright line rule that this is never available. Obviously, if someone reads the history as saying
I'm spotting you that for the purposes of my question.
Great.
I'm not granting
I thought you might not, Justice Gorsuch.
But I'm spotting it to you, and I'm just saying, well, okay. what would that look like, and how would that be any different from what we have experienced over the last few decades?
So this is a way in which my first bucket and my third bucket are actually going to relate for a moment. So I think this is
No.
it's helpful, I
You don't
promise.
get to squiggle out into the first bucket, okay? We're in the third bucket.
I'll answer for the third bucket, which is I think it requires having district courts consider the availability of the alternative and explaining why it's not workable in the case.
I think we've told them to do that, and gosh, how many times do we have to tell them to do that? And I think, in fairness to them, that's what I think they have. So let's, again, would any case of the last 30 years come out differently under your view of the rule in the third bucket than has?
Yeah, so there's a couple of examples where we don't think universal relief was appropriate. I'm most familiar with the state litigation, so most of my examples will probably come from there. But I heard my friend on the other side mention the DACA litigation, where Texas sought the termination of DACA, and ultimately the Fifth Circuit terminated DACA specific to Texas alone. And we thought that that decision was exactly right because of the nature of the harms in that case meant that Texas could get full relief for its harms.
Well, now we're back to the first bucket. We're just satisfying
I take the point. I'm so
you see
sorry.
what I'm saying?
I take the point. Yeah.
I
So
mean,
I think-
I get that we're going to always revert back to the first bucket, but that means the third bucket's empty. And
I totally take the point. I think AARP is a good illustration of the third bucket that this court confronted recently, where it was the case that there was this.
Notice the grilling from the men, too. Roberts was more confrontational. Gorsuch is more confrontational, even in a playful way. We'll take one, we'll take two, but
Rush.
you are empty in this
Just
third
a few
one.
hours, not possible to go through class.
Love to see it because, I mean, there's going to be pushback from both sides, but it's insane to me that it's split this men-women way, and the men are just absolutely fucking morons.
Certification. You heard my friend on the other side talk about the rigors of class certification, and I don't think my friend on the other side would agree. It could be done in 3 hours through the night, and so there were necessity to step in.
Do you agree about the rigors of class certification? It seems to me that 23B2 classes, and you probably, if you have to, are going to be arguing that they're not so rigorous to meet for injunctive relief for national policies that are uniform.
So the most important thing that hasn't come up in the discussion this morning yet is that they're not available for state litigation. It talks about persons, it talks about appointment of class counsel, it talks about going through this certification process. States, I mean, this court's precedents are really clear about parents patriae lawsuits. States can't represent those individuals in class actions, nor would we try to. They can't represent us, and you don't have classes of states. So the whole framework doesn't apply to state litigation. So I understood how it might come up as an alternative for some other cases you might see in the future, but for the injunction you have in front of you from the states, the whole class device doesn't even work as an alternative. So I don't see how it can be the answer for us.
But why should you care if the class device doesn't work as an alternative if you have bucket one? Like, you don't really need the class device. I think what you're saying is, well, it'd be frustrating for states not to have the class device when the individuals have it, but I don't see why that's true if giving you complete relief in bucket one solves your problems.
So I should be very clear, and I'm sorry for the confusion on this. This goes back to my colleagues with Justice Gorsuch. When states are seeking the relief, states are seeking it in bucket one and bucket two. As an amicus to the other injunction I recognize courts are looking at, I think bucket three could be available. We aren't seeking relief when it falls into bucket three, because as I was saying earlier, we're not going to be seeking relief for other parties. This court's cases, like Brackeen, make very clear we aren't suing to vindicate the injuries that third parties and our residents are suffering. So when states come before you, the questions that you would ask are the alternative ways of remedying our injury going to be practically or legally workable? And you're going to ask, did Congress authorize it, which gets to the vacator question, which gets to the Hobbs Act question, and so on. And on that first bucket, which I think describes this case well, I had a hard time with some of the colloquies earlier today because I think they were missing some really serious burdens that the states are still going to have to bear in this case if we get something less than a nationwide injunction. I think it's going to hinder the administration of our benefits programs. I think it's going to hinder the participation in our benefits programs. And I think it's going to produce unprecedented chaos on the ground. And I might offer examples of each.
Before you do, I'm sorry, I got one more.
No, no.
How would you get this? How would you get the merits of this case to us promptly?
So there's two different ways that this court could think about doing it. So the first is, I heard a couple colloquies earlier today to suggest that maybe the states should sort of have to take some of the burdens on ourselves because, okay, some people move in, maybe that's just something that equity shouldn't care about. And it may be true, this is Hornbook equity, that in some cases states don't get complete relief for the harms that they suffered. We just have to eat some of the administrability burdens. But the merits have always come into that because that is just about remedying a party's own injuries. And the strength of the ability to remedy our injuries is going to turn on a